This is a production of O'Brien Communications.
Hello, friends. I'm Tim O'Brien. Welcome to Shaping Opinion 2.0. You may notice some things that are different already. As I mentioned last week, we took a hiatus last fall and we went back to square one. We did a lot of things, but here are the highlights. We're now on video. You can find the Shaping Opinion podcast on YouTube and Rumble, and you can get to both of those sites on shapingopinion.com. We've also changed the format. We're now shorter and tighter. Our episodes are now 30 to 45 minutes long. But the biggest thing that you might notice now is that we're no longer going to be doing evergreen episodes, or we're not going to focus on history. What we're going to do now is be more forward-looking. You'll still get those great guests and those interesting deep dive conversations that we have. But now we're going to focus on topics that are there are things that are shaping opinion right now, and then you can make up your own mind. Before we get started, I just want to make sure that you hit that subscribe button on YouTube, and give us a favorable like and review on wherever you're listening to your podcast. Speaking of great guests, I'd like to just give a little bit of background on the guest we have today, and then we'll get into our conversation. Today, we're going to talk with Mark Chutkow. He's an attorney with the law firm of Dykema. He's not actively or directly involved with the case we're talking about today, but he has followed it closely. Mark is an experienced and accomplished litigator. He represents clients who are accused of regulatory or criminal wrongdoing. He's a former federal prosecutor. He's worked on some landmark cases, and he's led the U.S. Attorney's Office in Detroit. Welcome to the Shaping Opinion podcast, Mark.
Hi, Tim. How are you?
Good. I want to give a little background on the case because a lot of people might not be familiar with the case, and then I want to get your opinion. So let's do a quick recap of the case. It started on November 30th, publicly, 2021. That was when Ethan Crumbley, who was 15 years old at the time, entered Oxford High School, a Detroit suburb. He went into the high school with a 9mm handgun. He shot and killed 4 of his classmates, and he injured 7 others. One of them was a teacher. Ethan was charged as an adult for 24 different crimes. He pleaded guilty to all of those crimes in October 2022. In December of 2023, Ethan was sentenced to life in prison without parole. Here are the students who died, just because I never want to lose sight of that, who the victims were. Madison Baldwin was one of the victims, Tate Meyer, Justin Schilling, and Hannah St. Juliana. So I want to ask you now, Mark, what happened next? This is not your typical case. I mean, not that any mass shooting is typical, but typically in a mass shooting, once the shooter goes to prison or maybe commits suicide in some way, the case is now all in retrospect. But now the case was just getting started for Ethan's parents. So how did that transpire?
Yeah, very shortly after the murders themselves, the Oakland County prosecutor, the crimes occurred in Oakland County, and so the local prosecutor announced within days that she intended to charge the parents, which was a very unusual circumstance. This is the first time in a mass school shooting by a child that the parents have been sought to be held accountable. And it was a very quick decision by the prosecutor, and but a very consequential one as well. And so, I was at the U.S. Attorney's at the time, U.S. Attorney's Office at the time. And so, I was watching it very closely from that respect, and I realized how challenging of a case that the Oakland County prosecutor was intending to bring here. Simply because ordinarily in criminal law in the United States, we charge people for their own commissions, their own affirmative acts. And here, what the prosecutor was intending to do was, in essence, charge the parents for their omissions, for what they didn't do, for the lack of their ability to safeguard the community from their child. And so that was very highly unusual. It was in some ways kind of stretching the boundaries of the law. And so not only did the prosecutors in my office take note of it, but prosecutors around the country. I think in part because of people want answers. This case tore at the fabric of the community in Oxford, small town and just north of Detroit, and they wanted answers. I think people around the country want answers when they see the repetition of these mass school shootings. What could be done? Who else can be held accountable? And so, so here with that overlay, the prosecutor ended up charging the parents. And in some ways, I think it captured the attention not only of the local community and the state of Michigan, but around the country, because in some ways it's a morality story, a story about bad parenting and how far we should extend responsibility for the misdeeds of our children.
When you read about other school shooters, these are usually minors, so other school shooters, you often hear similar stories to this. This is not totally uncommon, but I think you were quoted as saying that these were extenuating circumstances, and not every shooter will have his or her parents charged with crimes. What makes this case different?
Yeah, the facts here were fairly extreme in the respect of the amount of red flags that were available to the parents, that that they ignored, the off ramps that could have been taken that may have stopped this highway crash, so to speak, that were not taken. So what I said before, that this really dealt with acts of omission rather than affirmative acts, there was an affirmative act that is important in this case, and that was the fact that the father, James Crumbley, purchased the gun for his son. And he purchased it 4 days before the shooting itself, on I think it was Black Friday, just after Thanksgiving, as an early Christmas gift to his son. There was some discrepancy as to whether it was in fact a gift, which might be legal under the law, or whether it was he was purchasing it on behalf of his son as a quote unquote straw purchaser, which would violate the law. The son, at the time of his guilty plea, specifically indicated to the court that it was his money, that he bought it, that he gave the money to his father in order to purchase it because he wasn't old enough to purchase a gun on his own. So that was an affirmative act, but most of the case really revolved around what was not done. And here, the prosecutor wove a story together of parents that were negligent, who did not see that their son was suffering from mental health decline. There was evidence that he had had some hallucinations, that he had seen demons in the home, that he had seen was hearing voices, and that he was lonely. His only friend that he had in the community had moved away. So he was a kid in distress. And on top of that, his journal entries had some he wrote a journal, and he also texted his friend that had moved away. And he said very disturbing things in those journals and in the text to his friend. To his friend, he talked about his mental health concerns, the fact that his parents weren't taking them seriously, and that he felt like he had nowhere to go. But then in his journals, he was writing about the fact that he wanted to shoot up the school, that he was depressed, didn't feel like his life amounted to much, and that he was having violent ideation. A big question in the case was how much the parents knew. They claimed that they never saw his journals, that they were not aware of these text messages, but there were certainly other things that established that they did have a sense for a potential danger, not only of the son to himself, but potentially to others. They went on the day of the shooting. They were actually summoned to the school. Well, I should step back. Several days before the shooting, the wife, the mother, was texted or communicated from the school saying that their son was doing disturbing things, that he was searching online for ammunition. And rather than scold him or perhaps, find out what the problem was, she laughed it off and she said, "Look, I'm not going to judge you, but you next time make sure you don't get caught." And then there was like a laugh out loud emoji. And so it seemed like she wasn't taking seriously what the school was telling her about some disturbing signs of her son. And then the morning of the murders themselves, Ethan, the son, the 15-year-old son, was caught making drawings or notations on a geometry notebook, and it had some very disturbing things on it. And you've got it there in front of us. It showed a picture of a gun that looked remarkably similar to the 9mm Sig Sauer that the father had bought him only 4 days before. There was pictures of someone bleeding with bullet holes in them. There were statements to the effect of, "The world is dead, I need help," and just basically a cry for help, as though he really didn't have anywhere to go. And the school obviously saw this as a disturbing sign. They texted that picture that you showed on the screen to the mother, and she recognized that this was concerning because she immediately sent it to her husband, indicating that they had a emergency, I think was the term that she used. And then he responded with a kind of a descriptive term that showed that he was also very concerned about what was happening. So internally, between the two of them, they realized that this was a problem. But then when they got to the school, they were only there for 11 minutes, and they sort of blew it off. They wanted to get back to their jobs. And in fact, at the end of the meeting, I believe that the wife said, "Are we done here?" and then left. What they learned from the school officials was, again, they got to see this picture in more close detail, but they never asked their son any questions about it. They never asked their son about the gun that had been purchased only 4 days before. It was in his backpack at the time in that school setting, but they never looked for it. They never asked him about it. They never asked him how he was doing. The school officials indicated their concern and that they thought that Ethan needed to get mental health counseling. The parents said that they really didn't have the ability to take him home at that time because they had to go back to work, but that they would look into and get him some mental health treatment. They then left, and it was only hours later that the son went on his shooting rampage.
They left him at school.
That's right. They left him at school. They went back to work. The prosecutors called the mother was a marketing director for a real estate firm, and they called her boss to find out whether she could have taken that day off from work, whether there was any issues there that required her to be at the office, and he said no. The husband was a DoorDash driver, and he obviously gets paid for what he does, but neither of them took it seriously enough to go home with the son that day, and then the terrible events followed. So I do think that the one thing that the school has been blamed, they've actually been sued by some of the members of the community, parents of the children that died and others who had been injured. And there's been a lot of talk in the community as to why the school is not being also held accountable for this. And I think there are some important questions there as to their level of understanding and acknowledgement for what happened. But at the same time, they didn't know something that the parents did, and that was the gun. And had they known that, we might have had a different circumstance.
It's like so many of these types of cases where there's so much blame to go around, and obviously in this case, it fell on Ethan. Was he tried as an adult?
Yeah, he was. He wasn't tried because he pled guilty, but he was charged, and his case was transferred over to adult court, where he pled guilty and ultimately was sentenced to life in prison without parole.
I have a legal question about that, because if you're going to charge someone as an adult, do you still hold the parents accountable?
Well, that's a question that others are asking too. But, oftentimes in cases where multiple people have had some sort of responsibility for harm, you charge more than one person. So, in like a gangland shooting, you may not just charge the shooter, but you're going to charge the getaway driver and the other people, the accomplices. Here, parents were not charged as accomplices, but they were charged for their own failings in protecting the community from Ethan.
In so many cases, you always hear about warning signs that people didn't catch. Even if it's not necessarily a mass shooter, you'll hear about certain crimes, and you'll find out that the perpetrator was pulled over by police 2-3 hours earlier, 2 days earlier. Why didn't they see the warning signs? So many red flags. In this case, it was followed through, I guess, to its conclusion with the charging and conviction of the parents. Why do you think this case was brought at this time against James and Jennifer Crumley?
Well, I think that the community was just in complete shock and outrage, and it came out fairly quickly that the parents had some role here, including the purchase of the gun. Some of the warning signs started leaking out, and I think that the prosecutor was in some ways reacting to the community sentiment and the horror at what had transpired. Although I don't think that this is going to result in a landslide of these types of cases, there are other examples of cases like this that have been brought. I mean, there was a case out in, I believe it was Newport News, Virginia recently. It wasn't a mass school shooting, but a mother was charged with child neglect because she left her gun out on her bureau, and her 6-year-old son picked it up, took it to school, and shot a teacher. And so not only was the mother held responsible, but also right now one of the school officials is being charged for her not taking action, despite the fact that a number of students and teachers told her allegedly that the child had a gun. But I do think that it goes to just a general sense in our society that protecting our children is one of our foremost responsibilities. And when you see a mass school shooting and people want to feel like something is being done about that, so these things don't happen in the future.
Well, this was one of those, I guess they're all weird cases, but this was kind of strange too, because as the case went on, Jennifer Crumley, in her defense, revealed that she was having an affair at the time of this crime. So she had not revealed this. Her husband didn't know at the time, and her son didn't know at the time that she was having this affair, but she brought it in, and I guess they interviewed her boyfriend as a witness on her behalf, because he could corroborate, she thought, or her lawyers thought, that she wasn't completely irresponsible in this case, because she had conversations with him and text messages with him that really, when you read them, she blames the school more than herself for anything that happened, for not picking up on the warning signs, for not searching the bag that you mentioned, for not taking more aggressive action when they saw things that were troubling. So she tried to basically pass the responsibility off onto the school and use that as her defense. And her evidence for that were these text messages with her boyfriend. So that all came to light too. Was there ever a time, I think, in her case or in her husband's case, James's case, where they could have been found innocent or maybe just not guilty?
It's always hard to Monday morning quarterback defense strategy in a case. Each of them took a different tactic in this case. The wife, Jennifer Cumbley's case went first. She testified on her own behalf. And some of the jurors indicated that some of her testimony on direct was very off-putting to them. For instance, she was asked on direct examination if she could do it again, if the time was moved back in time, would she have done the same things that she had done? And she said that she wouldn't have done anything differently. And the jurors, after having witnessed and watched the videotape of the son's rampage and the horror of that, I think were alienated by that statement. So that didn't help her. It's a curious thing to introduce the fact that you were being unfaithful as a potential defense. I think the prosecution seized on that to basically portray her as someone that was looking out more for herself and her activities and the things of her enjoyment rather than seeing the signs of her son spiraling downhill. For the husband, he decided not to testify. Maybe he was trying to not make some of the mistakes of his wife, but he had his own issues and concerns that the prosecution did a pretty good job of exploiting. He was the one that purchased the gun. He was knowledgeable about gun safety. He was the one that was responsible for locking it, for safe storing it, and yet it turned out that the gun safe was still at the 000 factory settings, that the cable lock that you can actually put through the gun itself to disable it had not been used. The gun had simply been left hidden in his bedroom, and the son was apparently able to find it. So in each of these cases, the defense tried different strategies, and in both situations, the prosecution was able to prevail. And so there was some, I think, lack of unanimity, according to the reports. Early on, there was, in the initial voting stage, there were a couple of the jurors that were voting to acquit. But, as part of our jury deliberation process, they worked together and tried to come to unanimity, and they did. I mean, one thing that I thought was interesting to note was that that a large percentage of both juries were gun owners themselves. And so many people thought that this case might turn on issues of the Second Amendment and people's thoughts about gun control. But in fact, the gun owners were some of the ones who may have been toughest on the parents for their lack of responsibility in safe handling these guns.
Did you ever get a sense, I'm not talking about in the courtroom, but just in general, that people supported the parents or were critical of the parents based on any kind of political leanings, or like you just said, Second Amendment people, not necessarily political by party, but political by Second Amendment views or things like that? What was your sense of the mood of the public or the people following this trial?
I watched it more from afar. A lot of it was on video, and I was able to watch it that way. So I wasn't in the courtroom to get a sense of the environment there. But the reporting of it suggested that that most of the people that were there were really supporters of the prosecution in this case, and there were a lot of family members of victims and others that had been impacted by the case that were in the courtroom. So to the extent that there were people that were critics, let's say, of the prosecution, I would say that that was something that maybe around the country, there were, I think, criminal defense attorneys that felt like this was too aggressive of a charge, that this was expanding liability to areas that really aren't talking about the affirmative actions of the defendants themselves. And there was concern that maybe, other sorts of dangerous instrumentalities, whether it would be a knife or, something else, that if the parents did not keep that safe, that they could be responsible for that as well. And so those are legitimate concerns, but overall, I think at least within the community, the support was for the prosecution in this case, because it really tore at the fabric of the community, what transpired.
I guess you mentioned earlier Monday morning quarterbacking, and I don't necessarily want you to Monday morning quarterback the attorneys involved, but given your legal perspective on both sides as a prosecutor and also as a defense attorney, how would you rate the strategies and performance of the lawyers on both sides of this case?
Well, I think that the prosecution, certainly put forward a case that was obviously compelling enough that they could get back-to-back convictions, and something that a lot of people thought that they had a real uphill battle for. I do think that there's some potential appellate issues down the line that is going to have to be taken into consideration. There were the text messages between the son and his friend were introduced into the case, as well as the journal entries. There wasn't a lot of strong evidence that the parents had known about those journal entries and had read them. And so the defense really vigorously objected to their introduction, saying, what is the relevance of this? If you're looking at the state of mind of the parents, what they knew and what they ignored, how could they ignore something that they didn't see? They challenged it on the basis of the confrontation clause of the Sixth Amendment, saying that because the son did not testify, he apparently took the fifth and did not testify at trial. They had no ability to cross-examine anyone. The text messages and the journal entries were introduced, and they had no ability, let's say, to counter whether they were truthful or not. There had been some reporting that that the son had spoken to a psychologist, and at least as to one of the text messages that he had sent to his friend, saying that his parents were being neglectful or dismissive of his mental health concerns. Apparently, the son had said that he was lying when he said that. So that kind of goes towards the potential reliability of that statement. But nevertheless, the court felt like there was enough indicia of reliability in those out-of-court statements that they should be introduced. And it's a kind of a technical issue. There are hearsay exceptions. One of the exceptions to the hearsay rules would be that it was what's called a present sense impression, or a statement of one's mental state. Those are things that if you say them more or less close in time to when you're feeling these things or when you're perceiving these things, they're less likely to be manufactured, and then therefore they're more reliable. Those were the basis by which the court introduced these statements, but I would certainly expect that both the defense for the parents are going to challenge the introduction of these statements, and then we'll just have to see how the Court of Appeals looks at it. Ordinarily, when you're looking at questions of admissibility of evidence, I believe that the standard that the court would apply is an abuse of discretion. So that's a highly deferential standard toward the trial court as to whether she made the right call in introducing those things. But those were important pieces of evidence in this case. And if the Court of Appeals disagrees with their admission, that could call into question the convictions.
I'm going to take a step back now away from this case, because I'm going to ask you a question you probably get a lot, but And I know you mentioned something that I think is worth mentioning here, just for background. You mentioned before our interview that you have represented a 15-year or someone who was 15 at the time who was a prostitute, and she had a pimp, and he was abusive towards her, and she shot and killed him. And you're representing her pro bono. Is that correct?
Yeah, that's right.
So my question, because you're working pro bono, so you don't have to represent her, but obviously it's important to you to represent her and help see justice. So I'm going to ask a more broad question is, are there any types of cases that you won't take because it just doesn't fit with your own personal values?
Well, I tend to, just by virtue of the fact that I work at a larger law firm with more institutional clients, most of the work I do has to do with large business type issues, compliance issues, trying to keep people from crossing over to getting in trouble with the government in the first place. So internal investigations and things like that. That's the area that is my preference, and so I won't be taking on a lot of violent crime cases on a paid basis, or let's say someone accused of drug crimes and things like that. But I do think an attorney has a responsibility to give back to the community, and through pro bono is one way that one can do it. And the case that you were talking about before, I learned of it from the University of Michigan. Has a human trafficking clinic at their law school, and read through the case file and saw that there was this young woman, she's 24, mid-20s now, but 10 years ago, when she was only 15 years old, she was prosecuted for felony murder for the murder of a man, a 36-year-old, that was human trafficking her. And I used to, as a prosecutor, prosecute those kind of cases of human trafficking, and I know the ordeal that the children go through, and I just felt like she deserved representation in this case. And it's a situation of, actually talking about Monday morning quarterbacking, of looking at her previous defense back when she was only 15 years old, and ended up pleading guilty to the offense. And whether it really met the Sixth Amendment standards of effective assistance of counsel. And my assessment was it didn't. Her previous defense attorney has sworn under oath in an affidavit that he didn't do what he was needed to do in order to protect her. The state of Ohio has a Safe Harbor Act specifically designed to provide protection to victims of human trafficking that may have committed crimes associated with that. And that just wasn't invoked. She didn't get the opportunity to present that, and she ended up being transferred to adult court and sentenced to a 21-year sentence. And as a former prosecutor myself, it struck me as an injustice, and I just thought, I may not make money off of this, but she deserves to have a second shot, and that's why I do it.
That's on that note, I'd like to thank you for joining us today, Mark Chutkow. Thank you for joining the Shaping Opinion podcast.
Thank you, Tim.
To learn more about all that we talked about here, please see our episode page at shapingopinion.com. Make sure to leave a rating and review, and subscribe wherever you get your podcast. Want to connect? Check out our website, shapingopinion.com. Follow us on the X platform, Facebook or Instagram at Shaping Opinion. And make sure to join our Facebook group called Shaping Opinion Podcast Listeners. Shaping Opinion is a production of O'Brien Communications. Copyright O'Brien Communications 2024.